Hello, YouTube. I'm Vince White. I'm an employment attorney, and on this channel, we answer publicly posted questions from YouTube users getting folks the answers they need from an employment attorney. We have a question here from YouTube user LC-WP9VR. I really engaged with that username. I really found it to be a moving and meaningful username. I'm just kidding. I'm sure it was just an anonymous username. Okay, and LC, we'll shorten you. LC for short asked us, hello, Vince. Thank you for sharing your knowledge and experience in employment law. Least I could do, sincerely. If I do choose to file myself, by which I believe you mean file pro se, and find a similar previously filed case that matches mine, is it plagiarism to copy that attorney's claims? Is there a way to compensate them for their work? Or is it better to use it as a guideline for my own words? A video on this might be helpful to others. Okay, so I have long been advocating that pro se litigants go on Pacer to find many things, including what their complaint should look like, case law relevant to their case, how to structure their arguments, how to oppose a motion to dismiss, how to oppose a motion for summary judgment. There's a lot of things that you can find on the Pacer system, on the federal dockets, and and some of the state dockets as well, that can be really, really helpful to you. Pulling out of another law firm's or another plaintiff's lawsuit as publicly available is not considered plagiarism in our industry. We are not writers. We do write as part of what we do, but litigators fundamentally do not create content. They persuade. They argue, right? So while a writer might say, hey, don't copy that thing I wrote, I have never once heard a litigator say, hey, I saw you. You copied the case law out of my summary judgment motion on Jones v. Turkey. And it was pretty much damn near identical to what I said. And I'm very uncomfortable with that. I would like compensation. Any attorney in this industry would say, you want me to pay you for stating the case law in its current format? Well, I had to shepherdize that, and you should also, if you're a pro se litigant, be shepardizing. You should be making sure the case law you're copying is still current, still the most persuasive and relevant authority on topic, that it still holds what you are saying it holds, right? So no, I didn't copy it. I took the section from your very successful brief, and I applaud you, Monsieur Litigator. I think that you did amazing work there, and I think it was the best statement of the case law with all the best citations. It was very, very good. You handled it very well. You are a grand legal writer, counsel. And I took it, and I shepardized it. I made it my own. I applied it to the facts of my case, meaning I didn't just take it and copy it. I applied it, and I treated your motion papers like a treatise, a memo of law, in which I said that gives me a great start, and I applied it then to my case, my situation. So too, can you do that with a complaint, at least for the format and things of that nature? Listen, your facts will always be different. Every case is unique. So you can't really plagiarize in the same sense that you might plagiarize an author or a musician, right? It's just not really the same thing. All that being said, don't just copy, right? As we already noted, every case is unique. And so too must your papers be unique, and they must uniquely apply the case law to your fact pattern. That can be very, very, very difficult for pro se litigants. It's one of the hardest things for non-attorneys to get a hang of. I've had conversations with people where they think they have a claim for defamation, and it's just like, okay, what about the situation makes you think it's defamation? Well, they said something that wasn't true. Okay, that is one of the elements of defamation. Was there a publication? Was it knowingly Was it a knowing falsehood? Like, did they know it to be false when they said it? There's so many other pieces of defamation, and it's different from state to state, jurisdiction to jurisdiction. But the elements trip people up because they then don't want to apply the facts of the situation to the elements of the claim where they are, right? Case law works in a similar fashion. This is the holding of this case. Great. Good starting point. The facts of this case that we are quoting for this holding somewhat mirror the facts of our case at hand, but not perfectly. So does the holding still apply? Well, I think it should, because this, and this are similar. And this court that we're citing to is a relevant authority on this matter for the court that we're currently in, right? Like, sounds simple. It's not. Trips everybody up. Legal writers do it in seconds. If you're experienced in the industry, it is child's play. If it's new to you, it can be really hard. Not to say you can't do it. People certainly do it. I've seen pro se litigants do it. But those are the 1 or 2% of pro se litigants who are really, really well suited to this kind of work. They probably should have been attorneys of their own right. They just didn't go to law school or didn't want to work in an industry like ours, and now they're being forced to because they're in litigation, right? So they took the time, learned how to do it, did it painstakingly, methodically, and got it right. But I'm going a bit long here. The long and short of it is, it's not plagiarism. You should copy liberally, take from those who drafted before you, and build upon it. Mimicry is the highest form of flattery. They will not mind. If they do, they're full of doo-doo, and you should ignore them. Also, frankly, if someone's like, you should have paid me for that case law. Okay. That's a weird stance to take when you're working, especially in our industry, where you're profiting off of discrimination and sexual harassment. The default should be, I need to be helping, otherwise I'm the problem, right? And if you're sitting around being like, pay me for my case law that is publicly available, I don't know if you're really helping. Somebody already paid you to write that. There's not an hourly rate, a flat rate, or a contingency. I don't know how you got compensated, Mr. Counsel, but you were paid to do it. You didn't do it out of the goodness of your heart, more than likely. Could it have been pro bono? Sure. It's possible. Statistically, incredibly unlikely. Incredibly unlikely. So odds are you were already paid. That'll do. It's plenty for you. Glad you can help somebody else when they copy off you. The end. If this was helpful, LC, WP, 9VR, like, subscribe, comment down below. Share our channel so it may grow. Take care. Good luck.